Did you get a reply on it?
I just barely text her. I would
Okay.
just go ahead and get started.
All right, welcome this afternoon to our Board of Equalizations. For Utah County, we've got two commissioners here, Commissioner Sakovich and myself, Commissioner Lee. I'm not sure if Commissioner Gardner's coming or if she's on her way or not. We sent a text to see. I know there was a conflict in her schedule a little bit, but. Okay, we have the agenda before us. And we will start with our regular agenda and just start with number one, which is, that is not, I was hoping. We have our regular agenda. Regular agenda number one is to approve the minutes of the Board of Equalization meeting held on October 28th, 2021. Any comments, concerns, or questions to that? Oh, and by the way, I'll have to suspend the rules so that I can either make motions or second motions.
I motion that we adopt agenda item 1.
And I'll second that motion. All in favor, say aye.
Aye. Can we just go ahead and just do several at one time here, 1 to 4?
We can probably do the next one with the minutes. Do we need to separate any of the other two, like 3 and 4? Do we need to separate them? We can put them all, lump them all together? Okay. All right, we have on agenda item number 2 is to approve the minutes of November 10th, and item number 3 is to approve the Board of Equalization assessor approved review process report, and number 4 is to approve the Board of Equalization hearing process report. Are there any questions to those?
None.
Okay.
Make a motion to adopt agenda item 2.
And 3 and 4.
And 3 and 4, excuse me.
So I got a motion, and I'll second that. I got a motion and a second to adopt or approve items number 2, 3, and 4 as stated on our regular agenda. All in favor, say aye.
Aye.
Aye. That passes 2-0. Number 5 is to approve or deny an owner request to change taxable status from secondary residence to primary residence on the parcel stated.
Both 5 and 6 are well documented.
Okay.
I can answer any questions or briefly summarize the situation if you'd like me to.
If they meet we're going from secondary to primary, so that's easy enough for me to do,
Okay.
unless you have any questions.
I can make a motion we adopt 5 and 6 both.
And I'll second that. All in favor, say aye.
Aye.
Aye. That passes 2-0. Number 7 is to approve or deny a petition of the Board of Equalization to hear an appeal of property valuation after the filing deadline. And I believe it is, they're claiming that it is a failure of notification.
Bert Harvey, Clerk Auditor's Office. I looked at the property history on this one. The property was created in 2020. Both the tax notice and valuation notice for both 2020 and 2021 went to the same address and was not returned as undeliverable. So we don't have any data or information that shows that the notice was not correctly sent out and timely sent and sent to the correct address at this time.
In the past, they've paid off the same.
Yeah, that's a great question. Let me go ahead and pull up Autoline. But yes, it does not look like there's been any issue with paying the taxes on time. So,
Okay.
I see that it was typed in here, they're claiming factual error. Is that,
I believe number
notification.
7 there on item number 7, they're claiming failure to notify is what they listed as their reason for filing delayed appeal.
okay.
So essentially, the law, the guidelines that we work under is in terms of the notification. It means that the county, by through error or either through error on purpose or on purpose. I don't know. Looking for better phrases. Anyways, the error that the county did not send out a notification or knew of an error with the notification and did not correct it before the notification was sent out. So basically, there has to be some fault on the county's side. Typically, the state tax commission has not recognized owners who claim they did not receive the notice, and as long as the county can shows that we made the attempt, that we actually sent the notice out, we sent it to the address of record, to the owner of record, and there was not sent back to us, and there was no known error. Typically, the state tax commission has not recognized that as a viable reason to accept a late appeal when we've gone before the state tax commission on these in the past. So basically, all things considered equal, the county has done their part. We do not know, obviously, what happened after it left our, left our hands and was actually sent to the owner. Mail can get lost. It can be not opened. It can be set on someone's countertop. It can be delivered to the wrong house. So
And you always submit it, about a month before it's due?
the notices are sent out every year by the statutory date of July 22nd. Typically, we get them out a few days before that. I believe the notices this year went out by July 18th. Of course, we use a mailing vendor who sends them. In this case, I believe they got mailed from Arizona. So probably takes a couple more days given the COVID standards, but that notification was never delivered. Again, we don't know what happened. We just know that we complied with the requirements to actually get the notice sent out to the owner of record.
The deadline is September 15th, so it's almost 2 months.
Yeah.
Right. And you were saying, Bert, that you don't know if the notice got lost in the process? Is that what you
Yeah, I
said?
mean, we don't know if the notice got lost in the process. So.
Okay. And they've had that property for, let's see, a couple days. Just since 2020 or 2019, excuse me.
Yeah, the serial number is created for the 2020 tax year, which means the first year that it was taxed as the current parcel was 2020. So we would have sent out a valuation notice and a tax notice for both 2020 and now 2021. So unfortunately, I don't have any greater history than just the last 2 years.
And the appeal is coming up. Kirsten Mann from Springville. They said they never got it. And the notice was sent out of Arizona, you said?
If I'm correct, I'm trying to remember where we use the company called Masters Touch to send out and they're doing both the tax notices and the valuation notices now. I believe they do the direct mailing out of. I think they send them out of their Arizona office, but it might be Washington.
So
It's definitely out of state. It's one of those two states.
So our systems, they're collecting up our property tax valuations in Arizona and sending them out?
No,
Or
we're
sending the information to them and then they mail it from there?
Yeah, they
back up
produce
here?
the notices and mail them out. So,
Okay.
Similar to how the elections office has a ballot vendor that
Right.
sends out all the ballots, produces and sends out the ballots.
I'll just surprise Arizona.
Well, I think it might be Washington, but I mean they do the mass mailing for a lot of counties. So.
Clarissa with the assessor's office. I would also like to point out that the notices are always available online. And so we go above and beyond to make sure that they're notified.
And I would like to point out that we do have an electronic format where they can sign up for that, but this owner has not signed up to receive the notice by email. So it's not an issue of where the email failed or something like that. So they are still receiving paper notices. They have elected to continue to receive paper notices.
So they've been there since 19, so 2 years of this year, at least for what we have on hand.
And I did upload the notice history as part of the documentation
Right.
for your review.
Yeah, I'm looking at that. and her appeal. I'm a little bit of a quandary here.
So I realize, I think it's unfortunate if what she's saying in here is correct or not, but we don't know. But I think according to the standards that we have, I'm inclined that it would have to deny this petition as I've read through it, just based off the standards that we are trying to follow. But I also recognize that with the two of us here, we have to be unanimous in it too. So,
For the record, the taxes have both been, the taxes both for 2020 and 2021 have been paid and were paid on time.
Yeah. So this is the first time.
I'm sorry, say that again,
It
Commissioner.
was paid in the previous year, as you're saying.
Yeah. So the first time this parcel, as in this configuration, this parcel itself was assessed and taxed was last year. The property owner paid the taxes on.
So what happens if we deny this? Then the owners will have to go to the state to appeal it next.
They would have to take their appeal to the next level.
So we would notify them how to do that.
We'll
process.
send them out. We'll send them a denial of their petition. They could then petition the state to overturn the board's decision on some basis of error. So
Okay. I'll make a motion that we deny agenda item number 7.
I'll second that motion. All in favor, say aye.
Aye.
Aye. Number 7 has been denied. Number 8 is to approve or deny a petition to the Board of Equalization to hear an appeal for the valuation after the filing deadline. This one appears to be for factual error. And who's going to speak to this one?
This appellant contacted our office. They've submitted photos taken around the first of the year. I believe there's a compelling reason to approve it, and then we'll let the appraisers follow up and determine just
Saw the
exactly.
photos for the basement, and I guess it's easy to check if there's a 4-way inspection or not that was
Right.
completed. So you concur that that we could probably approve this one.
Yeah, because they were going to finish a portion of the basement and then decided not to. It was just they were running into excessive costs, and so they did not finish it. But we picked up 25%, I believe, and we assessed it at 70%. But the photos that were submitted indicate that it's possibly less than that.
Right. Thank you. Is there a motion to approve this petition?
Yeah, just finalizing the review here. Yeah, I can make a motion to approve agenda item 8.
I'll second that motion. All in favor, say aye.
Aye.
Aye, that passes 2-0. Number 9 is to approve or deny a petition to the Board of Equalization to hear the appeal of a property valuation after the deadline, as stated here, and this one seems to be for they're appealing for extraordinary and unanticipated circumstances. Their reason was that they were serving a mission for the church in Oklahoma and did not get the mail in a timely manner. That's what I have listed here.
Yeah. And is the content in the agenda, everything that's in the online version up to date? Because we had a follow-on email said there was the property information was incorrect in the original agenda.
it was just the parcel number.
Parcel number,
Commissioner, yeah.
okay.
So this appeal actually has 3 parcels that are part of it. Historically, I was not home to receive the notice. Has not been affirmed on appeal up to the State Tax Commission. There's been a number of these appeals have gone before the State Tax Commission when they've been denied by the county. It's probably hard pressed to claim this is an unanticipated or extraordinary circumstance. So
I'd
this
make-
where this is a corporately held, these three parcels are corporately held. You know, yeah, you take that into account, that it's not just obviously the property owners that filed the appeal that could have, been watching this, and I would assume that they might have more people. Anyways,
I'm inclined to deny this one. I'll make a motion to do so. Deny agenda item number 9.
I'll second that. All in favor, say aye.
Aye.
Aye. That is denied with a 2-0 vote. Number 10 is to approve or deny a petition of the Board of Equalization to hear the appeal of property value after the filing deadline as stated in number 10. This one is for, again, extraordinary and unanticipated circumstances.
as far as I can tell, the notice was sent. I believe I've included the property, the notice history on this one as well. It looks like the notice has not changed into where it was being sent. And our notices, and they haven't been returned, and our notices do have information, a label on the envelope that states that they're supposed to be returned to us instead of forwarded. So given the circumstances, obviously when you have a mixed family like that, where, and I had this happen to me because I lived with my in-laws while we were building our home, and we had some mail snafus as part of that. So, it's easy to see how this could happen,
I'm inclined to.
but I don't have any evidence that it does happen, that it did happen.
I understand, but we're not physically there. I'm just trying to take at face value of the arguments. So I'm inclined to approve agenda number 10.
And would you justify that on the basis that they're saying that the address, that they didn't get the mail for 3 months, or that there was a change in the address that was kind of funny? I'm trying to read this.
Yeah, the explanation from page 1, the family members that were living with them moved at the end of May. They filled out a change of address form, but the postal system, as I read into this, indicated that the whole family is moving to the new address. So it was 3 months where most of their mail was not being sent or not received. There was a time that I was getting some of our kids' mail for a while, even though they were gone for several months, and they had sent a change of address.
Okay.
I'll make a motion that we approve agenda item number 10.
I'll second that. All in favor, say aye.
Aye.
Aye. That passes 2-0 under the extenuating circumstances. Number 11 is to approve or deny Board of Equalization to hear appeal of the property valuation after the deadline. And this one is get there. Well, they have 2 marked down here, so I'm not sure. They have 1 circled factual error, not the extraordinary error. So it's the factual error one.
It is for factual error.
Okay.
It's similar to the other one. It's a % complete issue. It's up in Soldier Summit. I checked with planning and zoning. They hadn't even been issued their certificate of occupancy when I talked to Steve Kitchen. And so they submitted photos to them, and Steve submitted them to me. So it looks like there's enough basis to grant it, and then we'll follow up and determine the exact.
Okay.
I'll make a motion to approve agenda item number 11.
I'll second that. All in favor, say aye.
Aye.
Aye. That passes 2-0.
Commissioners, I would just like to let you know that Peter Jepson has had his hand up for a while. I don't know if he had something to bring to one of the items that we've already discussed.
Yes, I'm so sorry to interrupt. It would be nice if the commissioners, as part of their ruling, on factual error can say it's limited to the factual error. Many times taxpayers think that once they've got it opened up, they can argue the value of the ground or this or that. If it's a percent complete, then the factual error is limited just to the percent complete and nothing else. So on factual errors, if part of the ruling could be that it is opened up, limited to the factual error only.
And so you're saying
Sorry to
if
interrupt.
we don't do that, then it's opened up completely? Or is it just
Well,
automatic? So either
well,
way,
they
if we don't
still-
say it, then it still is only
Well-
limited to the factual error.
It should be limited to the factual error, but they don't realize that. And so then they come prepared to challenge land value and everything else. And so on factual error, if we could just make the statement that it is limited to the factual error, that's all the county can look at. That's all the county can change.
Don't we send them a notification that it was approved, that their application was approved, and claim that or state that?
Yes,
It
we
just
do.
states factual error.
Yeah, we sent them a notification letting them know that the appeal was approved. But the letter we use is boilerplate, so we don't necessarily get into the details of what was approved on the letter. And so yeah, I mean, I don't know, and I don't know within the statute if basically the statute says that the statute and the guidelines say that the board can accept an appeal late for the following reasons, one of them being extraordinary circumstances, death of a family member, health situation, or a factual error. But I would probably lean on the attorney's office to give me an interpretation as to whether or not that means that if the board accepts something as a factual error, that only factual error can be argued. But in the process of a BOE appeal, when we accept an appeal and an appellant is making an argument about whether that's factual error or whether that's appraisal, or usually that's what the hearing officer, if it gets that far, is going to be considering the facts on. Is they're saying, well, you're making an issue of factual error, so that's what we're going to look at. I know at the state level, they usually let an appellant bring any basis for making an argument about an appeal. But usually at the county level, we make them stick to what they're trying to make their argument for in the first place. In this case, if this appeal had come in on time and it was a factual error, we would, the evidence and what the appellant and what the assessor's office would be basing their review on would be on the review of the factual error, not necessarily taking in the entire totality of the value into account. So I guess what I'm saying, Commissioner, is I don't know if it's necessary. But again, I would lean on the attorney's office to give an opinion on that. That would be, from a process standpoint, I don't know.
At the local BOE, they can say factual error, and then they can go from whatever argument they want to whatever argument they want. But I have numerous rulings from the state, and every time in the ruling from the state, they say this is limited to the factual error. So I'm fairly certain that is the way it is. I just hate to see the taxpayer think that they can argue all the way around the entire value when it's only the factual error that they can argue on a late appeal opened by factual error.
Just from a quick review, the standards of practice and the administrative rules do make it clear that the extent of the appeal is limited to the correction of the factual error. So that does seem to be a clear standard from, like I said, the standards of practice and the Utah administrative rules. I'm trying to find the state code section to see if it refers to it, but
Is that information provided to both those that have been approved and those that have been denied?
I believe that, like I said, Commissioner, when we
Did you
send
have
out
a
the approval
boilerplate
letter,
letter?
it's a boilerplate letter. We certainly could make a change to that letter in the future in the process.
Yeah.
My only statement towards that would be it probably doesn't matter, meaning that the appellant is going to say, oh, my appeal is approved, and regardless of whether we say we're going to look at the factual error or not, many appellants, if they have a mind to come and argue whatever they're going to argue, they're going to do that regardless of what we state in a letter or as part of the appeal or whatever. The hearing officers and the assessors, I mean, they're gonna follow what's required. In the case of a factual error, yeah, that's what the hearing officer is only going to look at is the
Certainly.
factual error, and that's the only thing the assessor's office is going to
Yeah.
make a review of
But
is
the
the
property
factual error.
owners themselves may not necessarily care to have
property
that
owners-
statute information in there.
The ones that are going to argue, they're not going to care what we say. They're going to
Okay.
try and make any argument
Okay.
they want to.
Okay.
Okay, moving on to number 12, which is to deny or approve the 2021 application for a new property tax exemption for Utah Food Bank.
I don't have any documentation for that particular one, only just my knowledge of them. On the website, I didn't have anything there.
Okay,
Do you have any documentation that you could at least give me a summary
this
of?
is it right here
I'm looking at it. How'd you find yours?
on the BOE agenda.
That's what I'm looking at.
Commissioners, I believe we've got Vicky Westergaard on the
Yeah.
Zoom call, and
see it on
I
there?
think there is someone on the Zoom call also
Yeah, I'm looking at BOE.
here from the
If I
Utah
go
Food
back-
Bank.
If I go back to it, so if I go back to are you on the agenda?
Yeah, I'm on today's agenda, BOE agenda.
So it's under,
Hi, this is Kent Liston. I'm the CFO at the
Yes,
Utah
there-
Food Bank. Can everyone hear me?
It's just.
We can hear you,
yeah,
Mr. Liston.
hold,
Thank
hold
you.
on one second.
Is that? This is what I have here.
Oh, that's weird.
Yeah, so you have it and I don't.
How'd you get to that page?
I went to the website and go to BOE agenda, news commission, there is that. I'll refresh it. And number 12, yeah, it's just, now 13's disappeared. Never mind, this is a different one.
Yeah, go back to your the agenda system. Regular agenda system. Yep. And then right.
There's commission,
There it is, right where you is. Oh no, you're right here.
that's commission, chambers.
Go back.
Commission, November 30, December 1, December 29. I was using the link that was sent to us by email. This is odd.
It shows up right there.
Yeah,
It says BOE.
try over here.
Oh, there it is, BOE.
That's December.
Are you trying to find the application?
No, yeah, well, there's a document missing on,
You
Yeah,
have to be
mine-
logged
mine's-
in.
yeah, I did that.
Okay, because it's not, she didn't make it a public facing document. Okay,
And so I went up here.
so that's commission meeting, that's 29th.
Correct, I've been trying to find, it just doesn't show up there.
Let's go back to the calendar. January 13th.
January 6th, so I said March, May, July, September, November. It is right here.
Yeah, click on that one and then hit open.
I've seen,
We're so technically advanced.
I mean, I have everything except what he has there.
Okay, so it's right here,
Number 12.
number 12. And there's the document.
Incredible.
There you go.
So
Yeah,
the
it's not, it wasn't
The
public.
link sent to me, just producing.
All right, who's going to speak to this one on just that they filed the application, and is anything out of order with it? I mean, they're a nonprofit. There is?
There's some things the board may want to consider with this
Okay.
one, so, yeah.
Well, we want to hear it.
I think Vicky is going to give you the background.
Okay.
Okay. Utah Food Bank purchased some property. It looks like they signed their warranty deed in August of 2008 of this year, on August 18th, but they didn't apply or send in their email until October 6th, so it was not within the 30 days as required by code. And also, it says it's vacant property, but I don't know if they have gotten their license or they have, done broken ground or anything. Mr. Liston is here, and I believe Ms. Bott is here to talk for them.
Okay, are you?
Yeah, this is, again, Kent Liston. I'm the CFO at the Utah Food Bank, and we are in the planning process with with our architects, and we have renditions that are underway to build approximately a 70,000 square foot distribution center and warehouse. And our plan would be to break ground, sometime in the next few months.
Commissioner, since they didn't apply timely as code requires, and they have not broken ground and they're still in the process, since we're almost to the normal application period between January and March 1st, they may want to apply then, because, it's different rules then if they break ground or get their license in that period before March 1st.
So what's staff's recommendation on this?
So it sounds like the staff's recommendation is to deny this and then see once they break ground to go through the process at the beginning of January after.
Yeah, so the standard is that vacant properties do not qualify for the tax exemption because tax exemptions are allowed in this scenario for properties that are put to the exclusive use of a charitable purpose. And if they're vacant, they're not put to any use, much less a charitable use. So that's the problem here, as well as the 30-day deadline. But yeah, the vacant property is a significant hurdle. Just for Mr. Liston's benefit, when Ms. Westergaard was speaking about a license, I think she was referring to a building permit.
I'm sorry.
Yeah. So, a building permit is often accepted as basically the beginning stage of construction and dedicating that property to the charitable use. So.
Oh, okay. And this was new for me. I've done renewals on our existing building. So, this has been helpful just to kind of understand what the process was. And as I was filling out the information, it was a unique situation where we had property, but obviously the building was to come. So in terms of timeline, would we then, once we get the building permit, then are there any code or restrictions around doing something, say, mid-year? Like if we were to have a building permit in, hypothetically in February, would it be retroactive for like the beginning of the calendar year? Or if someone could just educate me on how that works, I would greatly appreciate it.
As long as you apply within the 30 days from when you get the license, the building permit, and start, then you could apply then.
Okay. Okay, that clarifies that for me, and yeah, to the point that was made, it is vacant land, and it won't be soon, and we couldn't be more excited about being able to serve the county that's growing so fast. But I think that gives me what I need. Once we get our building permit, I will go ahead and just resubmit updated information.
Yeah, that would fit the pattern for all the other charitable organizations that have land that they have not yet broken ground or have property permits filed yet. So then I'm inclined to go ahead and deny this application.
I'll second that. All in favor, say aye.
Aye.
Aye. That passes 2-0 on a denial.
Mr. Chairman, if I may, just
Sure.
for Mr. Liston's, information, a denial of the exemption this year does not stop the organization from applying again for 2022. And that standard filing time, if they get the building permit between now and March 1st, which is the first deadline, they can apply, and the board will be able to consider their exemption application again for 2022.
So he has 3.5 months to get that new filing back to us then.
Yeah, if they get a building permit filed before March 1st, then they would very likely be able to meet the qualification, at least on the exclusive use part. Obviously, whether they meet the other qualifications is always up to what's in the application. But that would fulfill that requirement.
Okay.
Okay, great. Number 13 is to approve or deny a 2021 application for a new property tax exemption for Now I Can Foundation. Any concerns?
Now I Can Foundation purchase a building to expand their business to, and they did apply within the month that they bought it. I just don't know the exact date because the warranty deed has not shown up on our system yet. It just shows October on the application.
Yes.
Joel Christensen is here, so he should be able to answer something. It looks like Tracy.
I think Joel's here as well. We closed on that property on October 20th, 21st. I'm not sure exactly what date the application went in.
The 26th.
Of October. Okay.
So you're well within the 30 days, just a few days after. Okay, and it is a charitable organization. I think we've stepped through all those little hoops with it.
Anything
We don't
else
see
we're
any,
missing on that?
we don't see anything there.
The only question I had was whether or not the board wanted to verify that the gift that they contribute to the community is in excess of the value of the property taxes that would be waived. But I'm not actually certain that's a requirement that's a requirement we have for healthcare facilities, and this is a physical therapist facility, so it seems awfully connected. I didn't know. I should have
It
asked
seems a
Nikki
little
beforehand.
odd for a brand new application because you can only
That's a
speculate.
good point. I think they have other properties that are exempt though,
They do.
so they might have. History.
We did in Provo, but we've sold that. We're moving our clinic to Orem, to this new property.
So for next year, they'll need to produce something to show what they're doing. Okay. I'm inclined to go ahead and approve agenda number 13 then.
And I'll second that. All in favor, say aye.
Aye.
Aye, that passes 2-0.
Mr. Chairman, again. Mr. Chairman, again, if I might make a point of information for Ms. Christensen's benefit, they're getting approved for this property for 2021. That they will still need to provide the continuing statement in 2022. So she's going to get a notification from us at the beginning of 2022. They'll require you to still provide your annual renewal every year. So moving forward.
All right. Thank you so much.
I would also like to bring up this is prorated for 2021 from the date of purchase.
That's true.
Just a clarification, that would be prorated at the date the deed was recorded.
Okay. Thank you.
All right, number 14 is to reconsideration of Board of Equalization appeal date September 24th, 2019, as stated number 14. So I see photos. So what's going on
I might just
here?
make a quick comment. This is the Robert Stevens.
Yeah.
Okay. Mr. Stevens appealed a number of parcels where the Greenbelt tax status was withdrawn. This is some months ago. The board might recall hearing those matters with Mr. Stevens. This parcel presents kind of a unique challenge in that Mr. Stevens appeared, and he appeared at the appeal, the Greenbelt appeal of these parcels. Unbeknownst to anybody at the county, this parcel had been sold and had been transferred to Mr. Morris, who I see on the screen. And so, again, the county was unaware that Mr. Stevens no longer owned this parcel. It was owned by, like I said, Mr. Morris had purchased that property, I believe, just days before the appeal before the Board of Equalization. Or a week or something. Yeah, just a few days, I think. Yeah.
A few days before he filed it.
A few days before he filed the appeal. Yeah, that's fair.
I'm not sure when he filed the appeal, but the purchase went through on the 2nd of August.
Yeah. And so the Board of Equalization ended up granting Mr. Stevens the relief that he requested. And so, again, county staff had withdrawn the properties from Greenbelt. The Board of Equalization granted his appeal to put him back into Greenbelt. And then subsequent to that, the county appealed that decision to the State Tax Commission, and the State Tax Commission overturned the Board of Equalization to take Mr. Stevens back out of Greenbelt. I think we're in the period of time, Mr. Stevens has since appealed that decision. The Tax Commission decision was made as a result of an informal hearing, and so Mr. Stevens has appealed that to take it to a formal hearing. So that's the status there. Now, because this parcel was in kind of this awkward situation where Mr. Stevens no longer owned it, his standing to even bring the appeal was questioned. This parcel didn't get appealed up to the state. And so it's kind of an orphan at this point with considering the other parcels and its procedure. So Mr. Morris's parcel here is kind of an orphan in the whole appeal procedure. And so it was my recommendation to bring this parcel back before the Board of Equalization so that you could have an opportunity to receive all of the information concerning the parcel. A critical component of that is ownership. I brought this to the board's attention months ago, and I think the consensus was, let's wait till we hear from the State Tax Commission to find out how they were going to treat the appeals. We just got that decision back, anyway, since the last Board of Equalization meeting, I think. So this parcel is back up for reconsideration. Again, you granted the relief months ago. The other ones got appealed and have been overturned, and this one's kind of an orphan. And so, again, you weren't presented with all the facts, and so that's why it's here now for reconsideration. I guess one of my thoughts is, at the very least, regardless of how the board decides on it today or on this agenda, at some point maybe it can meet up with the other parcels in the appeal process. But that may or may not be possible. But that's why it's before you today. It's for reconsideration based on the fact that the board was not presented with all the facts initially, and that there were material facts that were omitted from presentation. And with that, the board can proceed as.
So what's the status that it's in right now?
The status that this parcel is in right now is the board granted.
We're paying the full tax on it. I mean, yeah. We just barely got our tax assessment and should be paid by obviously the mortgage company. But yeah, we are paying the full tax on the parcel at the moment.
So if it was taken off Greenbelt then?
Yes, it was taken off Greenbelt with all the other ones.
Okay.
So this was taken off Greenbelt before Mr. Morris owned it. And so it was based on that time frame of production, not production that he is doing now or has since done. The rollback was done prior to that.
So Mr. Morris, was it your understanding when you purchased the property that it was going to be out, it was off of Greenbelt?
They actually pulled it out of Greenbelt a couple days before we closed on the home. And the way we found out it was pulled out of Greenbelt was our title company did one final search. So we bought it under the impression it was going to be in Greenbelt. It was in Greenbelt up until, it wasn't, obviously. And it is our intention to produce on this property. But, it was our intention to have it in Greenbelt. It was a big surprise to everybody, not to mention the back taxes being owed at the closing date, which was not fun. So
you paid the back taxes on it?
Robert wrapped it into the sale of the home, or the sale of the property.
So it was at closing, clear title was passed saying that there were no liens, since Greenbelt's a lien, and the rollback was paid. So the real estate documents say that all that's taken care of when he got ownership.
So why would we have to do anything with this property? Why don't we just strike it off the agenda?
Can I add one more thing to this?
Because he can make a reconsideration in the next cycle.
We put it on because Mr. Stevens kept presenting it and asking us
Yeah,
about it.
Mr. Stevens, even though the rollback was paid, is expecting us the money back.
So a decision of some sort needs to be made.
So the board granted the relief on this parcel. The board of Equalization said that the property should be in Greenbelt.
Okay.
So then Mr. Stevens says, well, if that's the case, I
got
want a refund.
I remember now. Now I'm catching back. Now you're calling it an orphan because it didn't go to this
It
state
didn't.
on the appeal process, but we had granted relief on it.
But at the time, he didn't own it when he presented that.
And so one of the
Mr.
problems
Morris owned it.
is if we were to provide a refund,
Who we give it to?
who should the money go to?
And then the real estate documents then are basically invalid, and how can you invalidate a real estate contract that we were not a part of?
Yeah, please don't.
So this one is just really in kind of an awkward, my hope was to just try to join them at least with the others, but.
And what process do you see with us joining it? Would we?
Well, I think regardless of the
reconsider?
action you take today, either party would have the chance to appeal. And then once it's at the state, I would expect.
So
I would
if
expect
you
the state or the
so if
county
you
to
deny
say-
this and say it stays off Greenbelt, then Mr. Morris, the current owner, would have the rights to appeal that decision to the state. Is that correct? Or
Right,
does it
or
still
even
fall
if you-
back on Mr. Stevens?
Well, that's a little bit complicated, but between the two of them, they'd have to figure that out. I don't think we would say.
We have to own the property to appeal.
So what Mr. Morris is saying is he paid more money for it because the amount of the rollback was added to the purchase price.
Right.
And then we're saying we're going to refund it back to the seller. And so Mr. Morris paid more than,
Well, we're not saying that. That's just what
that's the scenario.
is
If
a
we were to give a
possibility.
refund to the applicant, that would be Mr. Stevens.
Right.
But he already sounds like maybe he's already been made whole, and it's Mr. Morris that maybe actually practically paid the rollback through the sales price.
A point of clarification there is that the purchase price did not change after this was discovered by that last title search. So I guess in essence, Mr. Stevens would have paid that out of the proceeds that he was going to make from the sale of the home.
So it
The
wasn't
value
increased.
I lost was it was no longer in Greenbelt.
And so what he needs to do now is put it back in the Greenbelt by using the land that way.
Yeah, so Mr.
Yeah.
Morris has kind of an independent duty to get this thing back into Greenbelt, unless, of course, the appeal process is in their favor. Like, the other parcels are all going through an appeal process still. Mr. Stevens is still pursuing to get the whole withdrawal undone. Now, whether that would apply to Mr. Morris or not, I guess, is an issue, but
Because right now, it sounds like on the surface, I may be missing it. Maybe we should strike this and let Mr. Morris put it back into Greenbelt. And then he can then apply
On his own merits and on his own property.
on his own property, yeah.
right,
Yes.
I think that's, again, that would, that neglects that rollback value that was paid. That doesn't address that, but.
One, if I might, one thing to do here, and perhaps the county, it was prudent for us to bring this back before the board because, again, as Paul stated, there was information that was relevant to the board's original decision, which this was wrapped up in several parcels were appealed. If the board simply affirmed their original decision and requested and basically stated the property should stay on Greenbelt, that does create a complication about how that would apply. But the county assessor's office would then be able to appeal that to the state tax commission, and we could actually take that, and that could actually be then taken to the state tax commission. The argument being that the board approved the property be put back on Greenbelt, but the property owner that made the appeal didn't have standing, and then the appeal could, from the county side, could be that there was no standing of the property owner to make that appeal in the first place.
The previous property owner.
The previous property owner. So again, there could be, we could preserve the appeal rights, and the fact we didn't include this in the original appeal to the state was probably an error on our part in not including this because of the standing issue. We probably should have included that. That way it would have been wrapped up in the entire appeal, and so possibly avoided this mess in the first place. But right now, this parcel itself was not included in the original state appeal. If the board affirmed their original decision, it could go up to the state appeal now with the full information.